Temugo, holding this for Mr. Mwangi, the accused person. Mr. Mwangi, the accused person. The matter is coming up.
One, which qualifies this matter as one that should attract a cash bail. Your Honor, we invite the court to also be guided by Article 123(2), that such cash bail should not be excessive. Your Honor, we call upon the court, even at this early stage of the matter, to first determine, number one, the character of the accused person and whether she's one who would observe bail terms. Your Honor, the accused before you is a senior advocate. She understands the rule of law. There is no possible reason that she would fail to observe the bail terms. Your Honor, we also ask the court to ask itself of the likelihood of the accused person interfering with any witnesses Your Honor, from the charge sheet, the witnesses are persons well known to her. They are persons who've conducted business together. The main complainant, Your Honor, operates a restaurant just below her office. They are in the same building. Your Honor, she is not a flight risk. She practices in Mombasa. Her law firm is in Mombasa at Rari House. She resides in Mombasa County with her 2 young children. It's a person who will be within the court premises on any day that the matter is set to proceed, or even on call in the event there was any urgency to such attendance. Your Honor, of Kipruto Serem versus Republic, a landmark judgment with respect to cash bail and bail terms by Justice Mureithi, and invite the court in apportioning cash bail not to focus on the value of bond is not an approximation of the value of criminal charges. Under Section 123(2) of the Criminal Procedure Code provides that cash bail should be fixed with due regard to the circumstances of a case, but should not be excessive. And lastly, Your Honor, the rights and liberties of the accused person are guaranteed in the Constitution, and we ask the Honor, there has been good faith on the part of the accused person. The charge sheet reads 17.5 million. Your Honor, there has been part payments, 3 payments to be precise, of 2 million each, that have been made through RTGS to the complainant's account being Idra Company Limited, situated at the same building that she has an office. One of the payments were made as follows, with the court permitting. On 31st May 2024, a sum of 2 million was paid to the complainant's account. On 31st May, again, Your Honor, another payment of 2 million was paid through Stanbic account. And lastly, Your Honor, on 16th of August 2024, just the other day, Your Honor, another payment of 2 million was also paid on 16th of August 2024. 6 million. Your Honor. You know, she has not denied continuing to make the payments. She has availed herself through to the officers, to the investigators, which were accepted by the complainant. And so, Your Honor, there is essentially no criminality in the matter before you. And even as we pray for cash bail, we also invite the court to consider that this is a matter that would even be settled by negotiation, by civil procedure mechanisms, and even by mutual agreement. of the parties who are all known to each other. And I will pray for the court's leniency to allow the accused person to enjoy her freedom as we proceed with the matter before.
However, Your Honor, just one or two issues that counsel has brought up, which I wish to respond. Number one, counsel has indicated that there is no criminality involved, and this is a purely civil matter. However, Your Honor, it's our humble submission that indeed there's a reason why we brought a criminal charge sheet. There's criminal charges before you, with the criminal offenses together with the sections pursuant to the law clearly laid out. Secondly, Your Honor, we do appreciate that counsel has indicated that the parties have been negotiating. But Your Honor, as per the charge sheet, you may appreciate that this is a matter where the offense was committed sometime in July. Your Honor, we're currently in November. So the accused person has gotten ample of time already to negotiate. And as such, Your Honor, after all that time has elapsed, is when the state has made the decision to actually bring up charges against the accused person. You know, with those few remarks, as we said, we shall not be opposed to reasonable bail and bond terms. That's it.
Mine is just shortly. We have been directed that the court ought to consider the circumstances before granting bail. Of course, it has to be reasonable. Your Honor, the court should note that the circumstances in this case is nothing but 17.5 million. So while the court retires to make a decision on bail and bond terms, it ought to note that the circumstances are: number one, there is a missing 17.5 million, which is a charge for stealing by servant, and the remaining 9 counts are offenses against the state, which, even if negotiations were to occur, the other 9 counts are offenses against the state, which are on the bounce checks. So as you retire, please consider that the offense in question is 17.5 million, and bond should always be commensurate and reasonable with regard to the offense in question. That is all.
From my colleagues' submissions that there is nothing criminal about the charges before court. Our submission is that the charges are properly formulated under the penal code, so those are properly before court. On the issue of negotiations, Your Honor, for us to be here today, it's a last resort. We've attempted negotiations before. The part payments that were done have not been factored in with the charges before court. So those were other payments. What we have before court is the colossal sum of 17.5 million. It's the accused rights to be given the favorable bond terms. We do not oppose to that, but we wish that the court would take considerations into the circumstances of the case. Thank you.